हेलो दोस्तों एंड स्वागत है आपका स्लीपी क्लासेस में. Now today's topic for conversation is something which is extremely serious and something which has been continuously troubling our society in both the way in which the crime is committed and then in how to deal with it. And this is the issue of marital rape. And there has been a long ongoing debate about its criminalization, what it entails, how it is to be done, and very importantly, on whether it should be done or not. Now, this issue has again been in news, especially in February 2025, when the Chattisgarh High Court overruled a lower court's ruling in acquitting a husband. Right here, the Chattisgarh High Court observed that a husband cannot be charged with rape or unnatural sex for engaging in sexual relations with his wife, regardless of a consent, as long the only important term here being, which was again added later, as long as she is above 15 years of age. Right? So the incident of a woman losing her life and dying in the hospital due to the sexual savagery of her husband, that happened. Now, the trial court had convicted the husband and sentenced him to 10 years in prison, but the High Court ended up overturning the decision. Right? And why is that? This is because the lacuna in the current law itself, right, wherein they said that when you look at the current law in India, say the pre-existing IPC, right, तो जिसके अंदर ट्राई किया जा रहा था, because IPC for the ongoing cases is still being applied, the Indian Penal Code of 1860, right. Here the IPC does not recognize marital rape as an offense, and a husband's sexual acts against women, no matter how forceful, savage they might be, do not amount to either rape or unnatural sex under the given provisions. That is section 376, which amounts to rape, and 377, right, the read down version of 377, which deals with unnatural sex in the Indian Penal Code. Now, this is something which is not just something that India is coping with, but across the world, this happens to be a matter of great debate. Right? So, when we look at laws across the world, when we look at countries, only around 52 countries have recognized marital rape as a crime. And even within these countries, there is no uniformity. A lot of times, the way in which the crime is recognized is very different. The way in which penalties are prescribed, punishments are prescribed, are often very different from, say, ordinary rapes versus marital rape, right? So because of this reason, across jurisdictions also, there is a lot of issues that have been raised, right? However, when we look at this dilemma, we also come into come in perspective when we look at the kind of ways in which crime is perpetuated against women, right? So if we look at, say, India itself, right, ये जो public private dichotomy है, public private dichotomy, the difference which is raised between them, between the public sphere and the private sphere. Now, marriage is something that belongs to the private sphere, wherein therefore jurisdiction of certain laws has been restricted so as to not in any way hinder the sanctity of the institution of marriage. Then, very importantly, there is something the statistics also show that actually, when we look at violence against women, including sexual violence, a lot of times this occurs in the private sphere, right? We see a large percentage of women who undergo this violence happen to know the people who perpetuate this violence. It is happening within their household, so often relatives, siblings, husbands, right? So this makes the matters extremely complicated, and with marital rape, the complications arise even further. Now, what is this marital rape exception? Right? There is an exception clause, and that is why it is called the marital rape exception clause. That while there do exist laws protecting women against sexual violence of any kind, right, there is this exception that comes when it comes to marital rape, any kind of sexual violence perpetuated by the spouse. Now, the origin, when we look at the origin as far as India is concerned, right, now India was colonized, right, and especially when you look at the past criminal laws, though they have been replaced by the new criminal laws, but all the past criminal laws were made by the colonial government. So the origin of the marital law exception can also be traced back to the British understanding of law, right? So this goes back to the 17th century England, where Sir Matthew Hale's interpretation of the law said that you cannot hold a spouse or husband guilty of raping his wife because why? Because of this institution called marriage. Because marriage was not just a social act, it wasn't merely a social institution, but it also gave rise to certain legal rights. Now, in terms of these legal rights, very important to understand that this was the time where there wasn't any gender equality, right? Males were the preferred sex, right? They were the ones who enjoyed legal, social, political, all kinds of rights. And women, more often than not, were treated as the lesser beings. So, through marriage, what was assumed? That once the wife has married the husband, the wife ends up becoming property of the husband, right? Now this is something, when we look at capitalism, when we look at doctrines of capital, classical liberalism as well, this is an issue that has been continuously raised, right? In fact, this was something that even Engels talked about, that if you go back to the kind of doctrines that were perpetuated by people like Locke, when he talks of property, this property did not just mean immaterial assets around them, but in fact, this idea of property also included wife and children. And therefore, control over wife was very important to control progeny, to control their reproductive force, because this reproductive force was churning the labor for capitalism, right? And therefore, the rights of women also sought to be curtailed, right? So the Marxist criticism of this sort of the kind of discrimination that we see against women, for people like Engels, this was entrenched within the nature of liberalism and capitalism itself, right? So this is exactly what happened. To ensure these rights, the wife was now the property of the spouse, and therefore, regardless of her continuing consent, sexual intercourse was permitted for the spouse, and the wife had no right to retract that consent, right? So this is how you have to understand social and economic theories get intertwined with ongoing legal discourse. So now, within India itself, the British colonial legal system was applied with the coming in of the Indian Penal Code in 1860. And that is why the same idea of exception of marital rape also came to be included in the Indian Penal Code. Now, what about new criminal laws, right? We've been talking about that we want to get rid of the colonial hangover, right? The way in which the British colonial ideas and concepts are still entrenched in our ongoing laws. So now a new set of criminal laws were introduced, and within this, IPC was replaced by the Bharatiya Nyaya Sanhita. However, the fact of the matter is that this marital rape exception clause continues within the new criminal law of Bharatiya Nyaya Sanhita as well through section 63, which now explicitly provides an exception to the definition of rape, stating that sexual intercourse by a man with his wife over 18 years of age cannot be considered rape, right? So despite new criminal laws coming into being, this exception has been maintained. Now, contest kaise kare? What is the debate regarding the exception? Should it be removed? Should it not be removed? What are the steps that have been taken, right? What has the judiciary done? What has its response been? What have various law commissions and other standing committees really responded, right? So that is something that one needs to consider. Now, firstly, in the 1980s and 1984, there was the Harvinder Kaur versus Harmandir Singh case in the Delhi High Court, wherein the Delhi High Court now held that the Constitution of India, right? It cannot intervene in household matters. So what did it say? It said, listen, marital rape is again, what we started with, public-private dichotomy. This is within the private or the personal space. And therefore, this even limits the Constitution, saying that the Constitution is only going to restrict the public sphere, and when it comes to the private or personal space, it is going to take a step back. And that is why for radical feminists like Carol Hanisch, right, now this makes sense. The idea of personal is political, right? This is why this is so important, right? This debate in fact ends up proving this. So the High Court basically washed its hand. It said that, listen, the Constitution can't really intervene in this matter. Why? Because there is this chance that by making such laws, we might just end up destroying the institution of marriage, which is the foundation, which is the root, right, of your social organization, right? So the court also further stated that when it comes to the privacy of the home, married life, neither Article 21 or 14, your right to life and right to equality, they have no role to play. Now you also have to understand 1980s is a time when judiciary is still trying to cope up, where judicial activism is still coming in. So you have to understand within activism also there are various stages, and more often than not when it comes to marginalized communities, particularly women, and when it comes to entrenched institutions like marriage, activism also takes a lot of time to really come into picture because the backlash is even more, right? Now the 172nd Law Commission report again sought to look at the matter. However, it refrained from making any sort of criminalization of the marital rape. Why? Again, because they thought that any such step would lead to excessive interference in the institution of marriage. So now we see, so if we look at the reasons why this exception has been maintained, the first reason comes is because of the sanctity associated with the institution of marriage. So one of the first justifications which has been used, right? The first justification is what? That in the institution of marriage, any sort of interference is going to lead to the very tumbling of the institution, and that is something that we don't want to do because that is the foundation of our entire social organization, right? So this is one of the first justifications that comes into being. Then very importantly, यहीं से हमारी second justification भी आ जाती है. What? That law cannot penetrate the private sphere. That there is some difference between the public and the private sphere. There are certain restrictions, and when it comes to the working of the law, so much interference in the private sphere is something that we cannot expect, that we cannot approve of, right? So again, this was a major issue that comes into being. Now things started switching, and this switch or this debate became very important, especially in the aftermath of the Nirbhaya gang rape case, right? When there were increasing protests and a realization that the laws that exist to deal with sexual violence against women in India are not enough. They aren't strong enough, and they haven't been able to bring about the kind of change that one had envisaged, right? So the kind of social democracy that would create a space of equality and freedom for women was still missing. And therefore, in 2012, in a major departure from this debate, wherein existing law commissions, existing parliamentary reports had all sought to refrain from interfering into this idea of marital rape, the Justice J.S. Verma committee report took up this matter. And it said that, listen, one needs to, it's high time, one needs to criminalize marital rape, right? It said that whatever justifications we've been offering for this exception, these are a result of the outdated notion of married women being property of their husbands, and therefore they should not be able to take advantage of law to safeguard themselves. They said these are extremely medieval notions, right, of Victorian era laws and morality, and these need to change. However, this change really didn't come into being. But the Parliamentary Standing Committee of Home Affairs, it sought to look into this matter, and again the idea was that, listen, marital rape is going to create a lot of new problems. It might just lead to rise of, again, fraudulent cases also. How does one deal with that? So this is something that we are not ready to take up, especially because it deals with such an important and fragile institution like marriage. So we don't know what kind of effects, spillover effects, it might create within this institution. And therefore the criminal law amendment of 2012 that came into being, while widening the scope of sexual violence, did not remove the exception to marital rape. Another major justification which has been offered with respect to India is that women have access to a lot of alternative remedies as well, right? So for example, now the one exception which has been added to the exception of marital rape is the age criteria, right? That the spouse has to be over 18 years of age, the wife, right? So now those who are below 15 years of age, for example, the Bombay High Court in a 2023 ruling, right, sent a man to prison because the wife happened to be underage. Now for underage wives, there is also POSCO which exists, right? So prevention of any sort of sexual acts against children or who are minors. Now when it comes to adult women, they say while marital rape cannot be applied, you still have alternate remedies present. What are these alternative remedies? First, they say is creatively using section 498 of the Indian Penal Code, which talks of prevention of cruelty against women, right? So instead of sexual violence or rape, you can term it as cruelty. Next, they said you also have the protection of women from domestic violence act, right? So again, the clauses of this specific law can be used to punish the person adequately while marital rape is still not applicable, right? So they said you already have these alternative remedies, maybe use those. Now in the Anuja Kapoor case versus Union of India of 2019, a PIL was filed by Anuja Kapoor, which basically wanted the court to direct the government of India that you make certain guidelines and laws when it comes to marital rape. So just like the judiciary had, say, maybe come up with guidelines when it came to sexual harassment at workplace, following which the legislature was forced to come up with a law, she said maybe the same can be done with respect to marital rape as well. But the Supreme Court said no, right? This will again result into overreach, right? And the formulation of such laws, especially when it deals with a sensitive matter like marriage, is not the work of judiciary. It is the work of legislature, right? And the judiciary is only there to ensure that the laws are being followed through, and when they aren't, to prescribe the necessary punishment. So if you want, you should petition to the legislature, right? Somehow make them make the law, but the judiciary is not going to intervene in this regard, right? So now while all of this has happened, a number of times questions have been raised how the non-criminalization of marital rape is absolutely incorrect. And why is that? On what basis do they criticize it? Right? Firstly, they say this exception 2, right, which is the second clause of the exception to section 375, they say it is ultra vires. It goes against the right to equality which has been incorporated in Article 14 of the Indian Constitution. They're saying notwithstanding whatever the judiciary in the past has said, Article 14 ensures that people aren't discriminated against, right? So now they say that within the Indian context, this exception of marital rape, it is discriminating against married women, right? So if you are an unmarried woman and such a heinous crime is committed against you, these sections will be applied. In fact, another case that emerges in this criteria is that in case the spouses have been judicially separated, right? They are separated, then also the rape law applies, right? Then also the rape law applies. However, if you happen to be married, there is no security from rape and sexual abuses from your spouse. So therefore they say that you arbitrarily end up creating two classes of women based on their marital status, the married ones or the unmarried ones or those who are separated. and it exempts or nullifies or immunizes the men who commit such violence against their wives because they happen to be married. Then they also say that this exception also violates obviously your Article 21, right? Your right to life, the right to live with dignity, right? We've seen that in India the judiciary has interpreted it's given a very wide interpretation of Article 21, right? It does not merely mean animal existence. It says that you have a right to live in a dignified manner. Now the right to live in a dignified manner also means that I have certain bodily rights, right? I should be able to control my body over who has access to it or doesn't, right? And in this scenario, by not criminalizing marital rape, you are basically eroding my right to live with dignity. Then very importantly, because right to privacy has also been read in the aftermath of the K. Puttaswamy judgment. And within this right to privacy, we've seen various facets of privacy have been included, including bodily autonomy, right? And in this bodily autonomy, the idea of consent is entrenched, right? So when you're saying that we have to protect the privacy of the marriage, right? We have to protect the privacy of the social institution of marriage, right? Again, it leads to the debate of privacy of institution of marriage versus privacy of the individual being the wife, whose bodily rights or bodily autonomy is now being flouted. And how do you balance the two, right? While some creative work might be required, it has to be done in the effect of safeguarding this idea of right to privacy, which is entrenched within Article 21 of the Constitution, right? Now, one of the other justifications, obviously, which is often given when we talk of marital rape, is say marriage, especially in the Indian context, is sacrosanct, right? Is sacrosanct, and cultural values of India are not aligning with this idea of marital rape, right? And it might just lead to further degeneration of these cultural values, right? This idea of cultural protection versus rights of individuals is another aspect that one really needs to pay attention to. Now, when we talk of this matter, you can also draw parallels and comparisons. A great analogy in this context is again the debate between freedom of speech and laws on obscenity, right? How do you balance the two, right? So, for example, when we have freedom of speech, and again this has been seen in recent times, Article 19 Clause 2 mentions one of the exceptions, which is morality, for restricting of freedom of speech, right? That it shouldn't hinder, it shouldn't go against morality. But what kind of morality, right? What are you treating as being obscene? Now, the Supreme Court says this basically means public morality or social morality, whatever culturally or socially is accepted as being moral or immoral, right? So, on that basis, obscenity is often restricted. This we've seen again with respect to recent incidents in 2025 when it has come to India's got, latent, right, the entire issue with respect to Ranveer Alabadi and Samir Raina, that while certain things may be obscene, right, can they be banned, right, because they aren't in alignment with your social morality. However, what is more important? Is it public morality or constitutional morality? And very often public morality can be at loggerheads with constitutional morality, right? The same happened when it came to reading down of section 377 also, right? Decriminalization of homosexuality, giving rights to the LGBTQIA plus community. The idea was that this is a minuscule population, that public morality does not really align with homosexuality in India, but later on the constitutional morality ended up trumping due to the Supreme Court verdict, right? So now this debate emerges again, right, that this marital rape is often, this exception is justified on preserving marriage, family values and cultural values, right? But what about now constitutional morality, which also entails rights to the individual, to the person, which is wife, Right now, these are certain dilemmas that we as a society, we as a government, we as a polity need to deal with. Right? What do you think can be the way out? How do we balance these issues? Right? What is the way in which the same can be dealt with? Please let me know in the comments below. मूविंग ऑन, वेरी इंपॉर्टेंटली 2026 के लिए PSI के कोर्सेज की रजिस्ट्रेशन लॉन्च हो गई है. क्लासेस विल स्टार्ट ऑन 3rd of March, and very importantly, for a limited time period you can use the code sleepy20 to avail a 20% off on any of our courses as per your requirements. इसके अलावा आप हमारे करंट अफेयर्स मॉड्यूल का भी हिस्सा बन सकते हैं, जो कि अब 2026 के लिए भी शुरू हो गया है और वैलिड आपको एक्सेस देगा टिल योर मेंस ऑफ 2026. इस पे भी फर्दर 6000 पे आपको फर्दर 20% ऑफ जो है ये मिल सकता है. दिस वॉज ऑल फ्रॉम मी टुडे. थैंक यू एंड कीप वॉचिंग स्लीपी क्लासेस.